information in the matter of Crowter and others and specific interest for health and social care.
Yes, Mr. Coppell.
Good morning, my lord, my lady. On this application, I appear with Mr. Quintavale for the appellants and Ms. Smythe and Mr. Vanderman appear for the respondent. Can I check, first of all, on the papers that you have? You should have a concise bundle of papers which we filed for the purposes of the hearing.
Yes.
We also filed with the notice of appeal a core and a supplementary bundle. I don't intend to go to them, but
Got those.
But I may need to. So thank you. You should have my skeleton argument, which was amended pursuant to your order of last month, and in the concise bundle, a statement of the respondent's objections to permission to appeal. And you should have a witness statement from the charity Handicap, which we applied for permission to put in fairly recently.
Well, that, I confess, has escaped me.
And me.
Well,
Well, tell us at least when it was said to be filed.
Yes, it was last week. My solicitor will.
Okay, last week is good enough. And it's a witness statement which they're not seeking to file on their own behalf, but to provide to you. For us to see.
Yes. I will refer, I think, at only one point in my submissions to the contents of the statement. It's by way of reinforcement of some of the points which we make anyway. I'm sure it's
Have you discussed with Ms. Smith whether what should happen to this?
We haven't had any objection from the defendant to it, but no consent either.
Anything you want to say about it?
Oh, it's not cool, but we would submit that. So sorry. Two of the conditions, the first two conditions in that motion aren't met, and they haven't yet been addressed.
Just give us a minute. Yes. We'll read it. The lawyers will understand that means that we'll read it so we know what's in it. It doesn't mean that we have to take it in as evidence. We'll decide whether we do that or not at the appropriate time. Right. So, do you have some hard copies of it?
We don't at present, but I will arrange for some to during the course of the morning.
Right. Well, I hope that somebody has my clerk's address available, because he will, if it is sent to him,
Yes.
make sure that it's printed out and brought to us.
Yes, I can do that. And there's one additional authority which I had put on your bench, which I will come to.
Thank you very much.
My submissions, which is the Jepson case. My lord, with that introduction, I'd like to hand over to one of my clients, the first appellant, Miss.
Yes. So I see Ms. Crowter is here, and your other client, is she with you today or watching at home?
I'm sorry, my lord. It's
you have more than one client.
Yes. And
Ms. Lee Wilson.
there is Aidan and Aidan's mother, and Aidan's mother unfortunately is unwell.
I'm sorry to hear that.
She's had COVID, so she is not present. But I understand she was interested in following on the live stream.
Good, good. All right. Well, now I understand that Ms. Crowter wanted to say something on her own behalf before you moved to the legal arguments. Well, good morning. What would you like to say?
A witness My name is Heidi Ann Crowter. I'm 26 and I happen to have Down syndrome. But that doesn't hold me back from living a fun and fulfilled life. The law that allows abortion up to birth makes me feel that I am not wanted and loved. It makes me feel not valued and that people don't want babies like me. I think that the law is downright discrimination. People like me should not be discriminated against. When the Abortion Act was made, there was no Disability Act. People did not understand disability very well. So please let us appeal and change the law to make us all equal. I want people to see us as people and equals and not just a burden. Thank you.
Thank you very much.
Okay.
All right. Yes.
Thank you, my lord. My lord, as you will have seen from the skeleton arguments, this claim is a challenge to the compatibility with the Convention on Human Rights of Section 11D of the 1967 Act, which permits abortion without time limit, and so at any time up to the very moment of birth, on the grounds of risk that the fetus may be born with a disability. In doing so, it permits the destruction of disabled fetuses at a time when the destruction of a fetus without a disability would be a criminal offence punishable by life imprisonment. It would have permitted the destruction of Heidi and of Aidan, the third appellant, who was diagnosed with Down syndrome at 34 weeks gestation, so shortly before his birth, at a time when he was fully capable of a life independent of his mother. The Divisional Court held that Section 11D was not incompatible with the Convention, as you have seen, and we submit that this court should grant permission to appeal on both of the grounds in CPR 52.6, both that there is a real prospect of success and because there is some other compelling reason for the appeal to be heard. Now, you have heard from Heidi what the appeal means to her and to other people living with Down syndrome and their families who believe very strongly that Section 11D conveys an unacceptable message that their lives are worthless and certainly worth considerably less than those of able-bodied persons. And that was one of the points which you will see when the statement arrives in the statement on behalf of MENCAP. We say that this case raises profound legal issues regarding, for example, the legal status and rights of a viable fetus, whether the life of a disabled person should be treated as equally valuable, the extent to which the state must seek to regulate or at least guide the exercise of discretion by doctors in this field. These are issues which have never been fully addressed either in the domestic courts or in Strasbourg, and some not addressed at all. Some of the case law is now many years old, and these are issues of great importance to many people. In this case, of all cases, we submit that it is vital not only that justice is done, but also that justice is seen to be done, and that the courts give full weight to the arguments against compatibility of Section 11D, as well as to those in its favour. And it will be a consistent theme of my submissions this morning that not only did the Divisional Court reach the wrong conclusions, but that it reached its conclusions through reasoning which did scant justice to the submissions which had been made to it on behalf of the appellants. I will be submitting that at every turn the Divisional Court mischaracterised the appellant's submissions, made basic errors of analysis or understanding, failed to grapple with significant points in their favour, and summarily dismissed serious arguments which warranted, at the very least, a much more considered and nuanced approach. Now, before I get to the detail of the Divisional Court's findings, we say that there are, on any view, serious arguments against the compatibility with the Convention of Section 11D. Section 11D enshrines a very stark difference of treatment between disabled and non-disabled fetuses. As I've mentioned, a disabled fetus may be destroyed up to the moment of birth, when similar action in relation to a non-disabled fetus could lead to life imprisonment. That difference of treatment turns on statutory language of substantial risk, of physical or mental abnormalities, and seriously handicapped, which it is common ground, and what's common ground on the evidence, are no longer in common use and would not be used in statute today. These are broad concepts, substantial risk, seriously handicapped, for example, but there is no definition of any of the relevant terms and no statutory or even non-statutory guidance issued by the defendant to regulate their application. There is consequently enormous scope for variation in approach between doctors, which does lead, and we know from the statistics, does lead to the abortion of fetuses which do not have serious conditions. So, for example, on grounds of conditions such as having a cleft palate. It leads to abortion of fetuses on grounds of conditions which are fully correctable and conditions which will only manifest themselves much later in life. My client's particular concern is with Down syndrome, a very common reason for late-term abortion, which is readily detectable long before the ordinary time limit in section 11A has expired. And as Heidi and others have movingly attested, is a condition which in modern times is not a barrier to a happy and fulfilling life. Absent bad faith, which of course will be highly exceptional, it is simply impossible for anyone to supervise or regulate the exercise of discretion by doctors in this field, and there is no recorded case of this occurring. The leading expert international body on the protection of the rights of the disabled, the UN Committee on the CRPD, has called specifically for the amendment or repeal of section 11D on the grounds that it stereotypes and stigmatizes people living with disabilities. Now, you may have seen reference in paragraph 43 of the Divisional Court's judgment to reports of the UN Committee on the CRPD making a similar point in relation to the laws of Spain, Hungary, and Austria. Surprisingly, the Divisional Court did not mention in its description of the CRPD jurisprudence that it has issued a report specifically concerned with the UK and with section 11D, and criticises that very subsection, the very subsection that we are dealing with, on the very grounds that we say should lead at least to a conclusion that Article 8.1 is engaged. The equivalent committee of the UN on the elimination of discrimination against women has agreed with the committee on the CRPD in relation to section 11D, a point which again is omitted from the Divisional Court's account of the CEDAW jurisprudence in paragraph 45 and 46 of its judgment, and we have cited the relevant passage from the CEDAW report in paragraph 26.4 of our skeleton argument. Where the CEDAW committee aligns itself with the CRPD on the subject of section 11D. Now, 3 members of the Supreme Court in the Northern Ireland Human Rights Commission case, Lords Mance, Kerr and Wilson, as well as the High Court of Northern Ireland, have specifically endorsed the approach of the committee on the CRPD. So this is not mere unincorporated international law, which has remained only on the international plane. There is domestic authority at the highest level that the UN approach in relation to abortion of disabled fetuses is the correct one.
We have to be careful, don't we, when you describe authority. Obviously, we would accept that any observations made by the judges you referred to are worthy of respect, but they're not, in legal terms, authoritative for a proposition, because if they were, then we'd have to follow it. So they're the opinions of those judges whom you've named.
Yes, they are, and I don't say that their views on the UN committee's approach must be followed, no. But they are worthy of great respect, and in particular, and this does go first and foremost to the engagement of Article 8, where the Divisional Court summarily dismissed the appellant's submissions without giving any weight at all, yes, to the UN approach as endorsed by those judges. You may well have already seen the passages from the Human Rights Commission case, but just for reference, it's Lord Mance at paragraph 133 on page 201 of the concise bundle. Where he says between E and F that in principle a disabled child should be treated as having exactly the same worth in human terms as a non-disabled child, which he says is the consistent theme of the UN Committee on the Rights of Persons with Disabilities, expressing concerns about the stigmatising of persons with disabilities as living a life of less value than that of others, and about the termination of pregnancy at any stage on the basis of fetal abnormality, recommending states to amend their abortion laws accordingly. And Lord Kerr, with whom Lord Wilson agreed at paragraph 331 of the Human Rights Commission case, which appears on 247 of the bundle. And finally, by way of introduction, the facts relied on in this case arise in what we say is the most pressing of contexts, that of a fetus, and the life of a fetus, which is on the verge of being born, which is viable, which can live independently of his mother, which is a human life. And that is a sharp and important contrast with previous cases on abortion, both in Strasbourg and domestically, which have concerned fetuses at a much earlier stage of development. Now, those arguments, what we say are serious arguments against the compatibility of section 11D, called for very careful consideration, we submit, anxious scrutiny, to coin a phrase, by the divisional court, and one simply does not find that in the divisional court's judgment. Now, starting with Article 8, if I may.
Right, if you're embarking on your grounds.
I am.
Just give us a map in time terms, because we obviously have a fixed time period for the hearing. What's your intention?
My intention is to be around another 50 minutes or so.
By all means.
Maybe a little longer, but certainly there'll be plenty of time for this.
That's absolutely what we would have expected. And having interrupted you, it seems, I think, to us that there are two parts to this. One is to do with the argument about the existence of rights for unborn, and the other is to do with the impact of the legislation on living people, particularly those who have a disability of some kind, as a result of the message sent. So, is that really the two parts of the claim? Each of them, of course, has sub arguments, but it's right to understand matters in that way, is it?
Yes, it is, but more broadly, I think the one qualification I would make is that when it comes to justification under Article 8, although we get into Article 8 in part through the impact of the legislation on the living.
Yes.
When it comes to justification, one of the factors which weighs in the balance is, if not the rights of the fetus, then at the very least the interests of the community in the protection of unborn life.
Yes. No, I understand that. I wasn't trying to exclude that from Article 8, but there are, in a sense, two legal limbs to the challenge that your clients want to bring.
Yes.
And you're going to start, are you, with the Article 8 side? No doubt at some stage you'll deal with the Articles 2 and 3 aspects.
Absolutely. I was going to start with Article 8 simply because, following on from my introduction, we say it's a powerful example of the divisional court's dismissive approach to the claimant's submissions.
Right.
And if I could ask you to go to paragraph 100, please, of the divisional court's judgment, which is the start of its ruling as to why Article 8 does not apply at all. The court says that it's accepted that the decision to become a parent or not to become a parent falls within the scope of Article 8, but, as the defendant submits, that is to do with the rights of the pregnant woman and says nothing about the rights of others, including those like the first claimant and the third claimant who have been born. My Lord, it is simply wrong to say that Article 8 regards the regulation of abortion as solely to do with the rights of the pregnant woman. One can see that that's simply wrong from paragraph 49 of the divisional court's own judgment, where it sets out one of the key paragraphs from the Vaux and France case, and about 2/3 of the way down that paragraph, the Strasbourg court refers to previous commission case law, considering that Article 8.1 cannot be interpreted as meaning that pregnancy and its termination are, as a principle, solely a matter of the private life of the mother. Now, as we've outlined in our skeleton argument, there are lots of commission cases, court admissibility cases, which one can cite in further support of the proposition that abortion is not just about the rights of the pregnant woman. But it is, with all due respect to the divisional court, an obvious and a surprising mistake for them to have made to dismiss the Article 8 claim on that basis. Now, of course, I need to go on to make submissions about how the legislation impacts upon the rights of people such as Heidi. But the starting proposition that we are only concerned with the rights of the pregnant woman is just wrong. Common ground then that in principle Article 8.1 and the right to respect for private life may be engaged by laws which perpetuate negative stereotyping of disadvantaged groups in society. We've set out the relevant principle in paragraph 22 of our skeleton argument from the Aksu case in Strasbourg, page 11, paragraph 22 of our skeleton. It's the italicised words, any negative stereotyping of a group when it reaches a certain level is capable of impacting on the group's sense of identity and the feelings of self-worth and self-confidence of members of the group. It is in this sense that it can be seen as affecting the private life of members of the group. And then it becomes a matter of fact in this case, whether there is sufficient evidence that that section 1.1d has the effect of negative stereotyping affecting the self-worth of people like Heidi. And well, there was, we say, an impressive array of factual evidence to that effect, not just from Heidi. We've set it out in our skeleton argument in paragraph 23. We had direct first-hand evidence from Heidi and her mother and Aidan's mother. We had direct evidence from Lord Shinkwin, a leading figure and campaigner in the field of disability rights. And we had academic research from Professor Kathleen Shaw, which we included in the concise bundle, where she summarised her extensive work in establishing the impact of legislation such as Section 1.1d on people with intellectual disabilities in particular. We had Professor Hastings as well, previous views of the Disability Rights Commission. Now, none of that evidence was directly challenged by the respondent. There was no controverting evidence. And what the divisional court found is in paragraph 101 to 102. They said the facts of Acts 2 were different, which they were. But in paragraph 102, simply say we accept the defendant's submission that Section 1.1d does not interfere with the right to respect for private and family life of any of the claimants. Say it does not perpetuate and reinforce negative cultural stereotypes to the detriment of people with disabilities. Now, that seems to us to be it. There is a bald dismissal of the evidence. Now, we do not know what was felt to be wrong with Professor Shaw's account, why that was not sufficient to surpass the hurdle, or indeed why any of the other unchallenged evidence was not sufficient. They go on to say we're not persuaded there's any causal connection between Section 1.1d, focused as it is on the rights of pregnant women, again reference back to to 100, and their medical treatment, and any discrimination that continues to be suffered by those with Down syndrome. And we deal with that in paragraph 25 of our skeleton. If that is supposed to be an explanation of the full dismissal of the evidence as opposed to a separate point, well, it's contrary to the evidence of, for example, Professor Shaw, who did say that Section 11D contributes to continuing discrimination against people with intellectual disabilities, but also as a matter of legal principle, it's simply not the case, and no authority was cited for the proposition that negative stereotyping only interferes with Article 8.1 rights when it gives rise to identifiable acts of discrimination.
Yes. I was trying to understand what the court was meaning, particularly by causal connection, because, speaking of myself, I understand the point that you're making about how this links with the evidence or doesn't link with the evidence. I suppose they may have had in mind that in the Aksu case, what was apparently happening was, as it were, a direct disparagement of the group, in that case, the Roma group, in a publication. And so if that's what they were looking for, then I suppose you would say that is not the whole picture at all, because you can disparage people to a degree that would engage Article 8 in a number of ways, not all of which have to refer directly to them. So I wonder whether that's what they were meaning.
Yes.
By that, because it certainly, as you say, doesn't. The two sentences taken together don't sit easily with the evidence.
Yes. Well, Lord, you may be right that they were looking for an act of direct disparagement. We say that the test must be whether whatever is going on by way of stereotyping impacts upon feelings of identity, self-confidence.
Yes. In fact, by whatever means.
Yes, yes. But secondly, my lord, one really should not have to be searching for understanding of what the divisional court meant in two sentences, which constitute the sum total of their dismissal of an impressive body of evidence. It simply should not have been the approach in this case.
Well, this is obviously a point that we've had the opportunity to discuss, because you made it in your papers, and I think we grasp that point, but not wanting to prevent you from developing it, as this is a permission application rather than a full appeal. What I think we need to know is, where does that get you?
Indeed.
I mean, let's say, for example, that this was considered to be, at this stage, as it were, an arguably wrong conclusion. But there weren't any other arguably wrong conclusions. I think what we then have to consider is whether that was something that was bound to lead to, or should lead to, the grant of permission to appeal. Because I think we would all understand at a legal level that even if you made progress on that issue, that's necessary for you on the Article 8 point, but it isn't sufficient.
Yes.
Because there may be, even if your client's Article 8 rights were engaged, and they were then breached, there may be, as the Divisional Court found, good reasons for that.
Yes.
So would you at some stage, when you feel it right, give us your submission on that particular point?
Yes. Well, I'm coming on to it momentarily.
Yes.
I completely understand, and indeed it's the divisional court in refusing permission to appeal its reasons on Article 8.1 was, well, it doesn't matter because we went on and considered justification anyway.
Yes.
So of course I will address that. But just a final point, and trying to do full justice to what the divisional court reasoned on this issue. You have a section in 104 to 107 of its judgment on the international material, because it was at least a powerful submission of fact on our part that the international body with experience and expertise had taken the very view that we invited the division.
Well, what it boils down to is that your clients feel oppressed by this provision, and they have powerful support from international bodies. It's not just them.
Yes, and my Lord, 104 to 107 dismisses the views of the UNCRPD, and this comes back to have an impact on justification as well, dismisses them on the basis of the recent Supreme Court case of AB and Secretary of State for Justice. And we say dismisses them quite wrongly, because we were not at any stage inviting the court to make new law on the basis of international law principles which were unincorporated and so forth in the way that AB says you can't. What we were saying, which is entirely conventional, is that Article 8 should be interpreted so as to give effect and to be compatible with the international materials, as is well established, and as, for example, Lady Hale held was appropriate in the Human Rights Commission case at paragraph 5. So what the divisional court said in 104 to 107 was no answer at all, we submit, either to the factual point made by the UN committee or the legal arguments as to Article 8 needing to be interpreted so as to give effect to the convention. I'm sorry, to the CRPD. So turning then to justification, and the first limb of justification under Article 8 is in accordance with the law, and paragraph 32 is the start in our skeleton, and when we set out the principle and the well-known principles from cases such as Bridges in the Court of Appeal, law should not confer a discretion so broad that its scope is in practice dependent on the will of those who apply it rather than the law itself. It must afford adequate legal protection against arbitrariness and accordingly indicate with sufficient clarity the scope of discretion conferred, be accompanied by safeguards to guard against overbroad discretion. Well-known principles. And we say that the facts relevant to in accordance with the law are very stark in this case, as I mentioned in my introduction. The language used in the statute is no longer appropriate. There has been no attempt by government to give guidance, and there is a total lack of regulation or enforcement as to how the subsection is applied in practice. Simply impossible, save in cases of bad faith, which will be few and far between, of course, to challenge the exercise of a doctor's discretion. And as we highlighted in our skeleton, the only available guidance which of the RCOG from 2010, which I think the Divisional Court says at one stage was commissioned by the department, which it wasn't. The only available guidance is very broad in its terms and basically says it's up to the doctors and nobody will be able to interfere.
The competing thoughts about this are that on your side you say it's impermissibly broad, so much so that it's arbitrary, and the counter argument is it's deliberately broad because that's the reality of the situation, that it would not be possible for it to be narrower. So that's really the argument.
Absolutely. But, my lord, the way in which the Divisional Court addresses it, as we'll see in a moment, is not to say that it's impossible for it to be narrower, is to set up an Aunt Sally of it would be impossible for the discretion to be tightly regulated. I'll show you the reasoning in a moment. But what our argument is that there is nothing by way of constraint at the moment, and there could be more.
Well, is it fair to say there's nothing by way of constraint? Because the two doctors will, for example, have to be members of the General Medical Council, they'll have to be registered. They are under those constraints. And it is open to the GMC, for example, to take proceedings if it is thought that a doctor is not acting appropriately.
Well, I'm sorry,
It
I don't mean
can't
to
be said
exaggerate.
there's no regulation.
No, there is, of course, regulation of doctors, but the RCOG guidance, which is the only guidance available in the field, is not, in terms, does not give ethical guidance to doctors, and there is no question and no risk whatsoever when you read the guidance of any professional conduct proceedings being taken against doctors, unless they are seen to be acting in bad faith, which, of course, is one would hope is unheard of. But the result, and the Divisional Court set out relevant passages from the RCOG guidance near the start of its judgment. The result is a very wide range of possible conditions which different doctors may deem appropriate to justify abortion up to the moment of birth, including, and this is in express terms of the guidance, including conditions which can be corrected and can be fully corrected after birth.
Isn't, as my lord has already indicated, the difficulty is that because there can be any number of conditions arising in any number of circumstances, it is simply not possible to identify with precision the parameters within which a doctor should exercise his or her discretion.
Yes. So we certainly don't say, and we've never said, that there needs to be a list of conditions, and only these conditions will be will fall within the section. But what we do say and did say is that it is far from impracticable, as the Divisional Court seem to say, to have greater clarity and greater constraint over what sorts of conditions should justify abortion of a fetus up to the moment of birth. The way that the Divisional Court decided it is 111 and 112, and they use the words which my lady just put to me, impracticable to define with precision. Well, we're not looking for precision, but what there is at the moment is no constraint as to how the section is to be interpreted and applied. And it can apply, and I repeat myself, to a very broad range of conditions, including conditions such as Down syndrome, which we have been particularly concerned which are readily detectable before 24-week time limit in section 1.1d. Conditions which are correctable, conditions which do not produce any disability or handicap upon birth, but an example is a genetic disorder which is likely to produce illness or handicap later in life. All of this is apparently within, or can be within, section 1.1d, depending on the discretion of individual doctors. There is just no significant constraint upon how that discretion is exercised. It simply cannot be challenged. Bad faith, in theory, that aside, it cannot be challenged. And this is, and of course everything depends on the context, but the context is, as I said, a very pressing one: the destruction of a human life at the point of birth. If that is not an appropriate context for the maximum of practicable constraint and safeguard, then what is? So once one understands that we weren't arguing for, and the law does not require us to argue for, precision for every exercise of discretion, we say the divisional court's reasoning was in 1.1.1 to 1.1.2 was insufficient.
Is that the Ansali, you say?
Yes.
The arguing with definition with precision.
Yes. And one sees it later when one comes to justification, where the divisional court says it's not possible to have a precise list of conditions which would qualify. Again, that wasn't our argument. What it is possible to do is have more than what there is.
But you have to, I mean, you understandably emphasise the point about late terminations of viable fetuses, but you also have to take on the fact that, as I understand your claim, it would be to make terminations after 24 weeks in any circumstances unavailable. Well, so I don't want to make the mistake you charge the divisional court with, but I'm not sure there are any intermediate logical landing places for you.
Well, so Lord, I think that's quite how we put it. The complaint.
I know it may not be how you put it, but I think you have to face up to the fact that that if you are right about this, then mothers with children who had a late diagnosis would be compelled to continue with the pregnancy.
So what we say is that Section 1.1d, as it stands, is incompatible, that it's contrary to the Convention to have no time limit at all for this potentially very broad range of conditions said to amount to serious handicap or a substantial risk of serious handicap. One of the remedies we seek, and realistically the primary remedy that we seek, is a Section 4 declaration of incompatibility. So we're not asking the court to read down the legislation so that no termination after 24 weeks is permissible at all. We have a point about Down syndrome, but the effect of the Section 4 declaration of incompatibility is, of course, that it goes back to Parliament for a thorough consideration of the issues, and there hasn't been a thorough consideration of the issue since 1990.
Yes, we understand that, but I'm not sure that you can separate the point that I've just put to you, which you haven't answered, and the justification for making a declaration of incompatibility. That the two don't seem to me to be able to be separated out.
Well, I'm
And
not
I mean,
saying-
I'm
didn't-
not, in a sense, if it is your case, as well it might be on the basis of the evidence that you put forward in your instructions, that would be the consequence of success, then say it. But
So
you're not, at least with me, going to make any progress by sugaring the pill. I appreciate you have a very important point to make, but so do other people.
yes, Lord, I did intend to answer my Lord's point. So first of all, what we say about Section 1.1d is that it is not in accordance with the law for the reasons I've given, and is disproportionate because it is, for example, overbroad. So it includes within it conditions which are detectable before 24 weeks. It includes within it conditions which shouldn't be regarded as giving rise to serious handicap, etc., etc. Now, if the court were to agree that it is overbroad, and therefore a Section 4, it's disproportionate, and so a Section 4 declaration of incompatibility is made, then the effect of that is not that nobody can get an abortion after 24 weeks. It is that it becomes then for Parliament to give a further and thorough consideration to the issues and to decide in the light of up-to-date circumstances and attitudes to disability what the correct position ought to be. But there is no part of our claim which seeks to establish that any abortion after 24 weeks is impermissible, and that would not be the effect of a finding in our favour. Yes, we criticise Section 1.1d. It is too vague. It is doesn't have sufficient safeguards, and it is overbroad for a variety of reasons. But we're not seeking any order which would render or any kind of remedy which would render any abortion after 24 weeks impermissible.
Well, I engage you in that discussion because it's obviously an important point, but I don't lose sight of the fact that we're not here concerned with these issues, we're concerned with the different question of whether or not you have permission to appeal,
Yes.
in order down the track, as it were, to argue these issues.
Thank you. Proportionality, then.
Yes.
Lord, and can I'll take this. You've seen my skeleton. I think the most efficient way to do it is just to look at the reasons given by the Divisional Court on proportionality one by one, and they begin at 123. Now, 123 is the no consensus point. The Divisional Court says, whatever the precise number of states that permit abortion on grounds of fetal abnormality, see above, there is no international consensus in the Council of Europe on this sensitive issue. Now, the facts that were before the Divisional Court is, as we've set out in paragraph 36(1) of our skeleton argument, that there were 16 states out of 47 in the Council of Europe which permit abortion on grounds of fetal disability without time limit. But some of those were states which required, in addition to disability, some degree of impact on the health of the woman, on the physical or mental well-being, that imposed additional conditions. And Ms. Duncan from the department, who gave the evidence, acknowledged that some of the 16 states, or she gave 18, but she was wrong about 16 states, did have these additional conditions. So in terms of how many states adopt a similar approach to us, in having no time limit for disability and no additional conditions at all, we believe the answer is significantly less than even than 16. But what you don't find in paragraph 123 is any indication of what the divisional court meant by consensus. What was it looking for? It seems to be, and one can certainly read 123 as meaning that it was looking for unanimity or near unanimity of practice amongst the contracting states. But that would be, if that's what they meant, if that's what they were looking for, that would be wrong. On the case law, as what we had identified was a preponderance of practice against the state of our domestic law would have been sufficient, or should have been sufficient. One gets an example of this in the Human Rights Commission case in Lord Care's analysis of the ABC in Ireland case. It's paragraph 312 of his judgment, where he regards a significant degree of consensus as being 30 contracting states, 35 contracting states, and 40 contracting states. So one can't say 35 is fine, 34 is not fine. But,
well, if you, I mean, this may be helpful, but what you're telling us is that we've just taken at face value a third of the states have something similar. I appreciate you say that there are some tighter provisions within those, but that's what it looks like. Something like a third. Now, I'm not sure if you have three people and one of them disagrees that one describes that as a consensus. So I think we can all make our minds up about that.
Well, I mean, firstly, similar to the UK, in fact, it is important to understand whether there are additional conditions.
Yes.
And as I say, our submission was that there were significantly less than a third. But secondly, one simply does not know what standard the divisional court was setting, and if it was unanimity or near unanimity, that would be incorrect. We contrasted the position in our skeleton with Elan Kane, where Supreme Court says no consensus in a situation where only 5 of the contracting states did what we did. That's uncontroversial. But we're a very long way from that. And for the further reasons given in paragraph 36 of our skeleton, consensus or lack of consensus is not the end of the matter.
No. But the division court seems to have been particularly influenced by the fact that the court hasn't come out and made the point that, as it were, you're seeking to make. I mean, it was one of your opening observations that this has never been addressed by a domestic court or by Strasbourg. But the difficulty that you may face is that Strasbourg and the Convention is, as it were, the propellant for your case, but it hasn't said what you contend for. So I think when one looks at paragraph 123, they refer back to the fact that, as it might seem, the European Court of Human Rights has been very careful not to make this point. I mean, you may regard that as regrettable, but it hasn't gone as far as you're seeking to go with this claim.
Well, it's important to understand what the divisional court means in its final sentence, as we've already mentioned, Mr. Coppell is unable to point to any decided case in the Court of
Yes,
Human
I think
Rights.
I presume they're referring back to the Vaux
Yes. Yes.
jurisprudence.
Yes, they're referring back to Article 2
Yes.
in the context of an Article 8.
Yes, but your Article 8 claim is I appreciate it's conceptually different from the Article 2 and 3 claim, but in a sense they overhang the same fundamental issue, which is to do with the extent that to which the law is obliged, as you would put it, to remedy the concerns that your clients have. And that can be put in two ways. One can be put in regard to the unborn, one can be put in relation to those who have been born.
Yes.
But as it were, it all flows from the same source.
Well, my Lord, it's our complaint is a particular complaint concerned with essentially discrimination against disabled fetuses. That is simply not a matter which has been addressed by the Court of Human Rights, either in the context of Article 2, given that we're concerned with the viable fetus up to the point of birth, but certainly not in the context of Article 8. Now, at a permission to appeal stage, of course, if there was a Strasbourg case that was directly against me, then I appreciate that I would struggle. But what the position actually is, we submit, is there is no Strasbourg case on this point, and there is consistent international law practice which ought to feed through into Article 8, which supports us. And certainly paragraph 123, if the point being made is, well, he couldn't show us a case on Article 2 which supported him, therefore he's got to lose on Article 8 as well, we submit that can't be the right approach. Article 8 is a different challenge for a whole range of reasons. Also, showing no decided case in Strasbourg, that's a quite different point from consensus, from international consensus, which is the previous point in the
Well, the real point in 1, 2, 3 is wide margin of appreciation.
Yes, and to which they regard international consensus as highly significant. 124 then, they say in the domestic constitutional context, this is the field where it's particularly important to give Parliament a wide margin of judgment. And then the Human Rights Commission case demonstrates that margin is not unlimited, and the courts do have an important role to play under Section 4 of the HRA. We say that is a dramatic understatement of the effect of the Human Rights Commission case. It doesn't simply say that the margin is not unlimited, it's never unlimited. What it actually shows is that a majority, 4 members of a 7-member court, were prepared to find that the balance struck in legislation for Northern Ireland was incompatible with convention rights. And Lady Hale made specific comments in 37 to 38 of her judgment on the issue of relative institutional competences between Parliament and the courts in the field of abortion. This is not a matter on which the democratic legislature enjoys a unique competence. Courts are as well qualified to judge as the legislature. To say that the Human Rights Commission case only demonstrates that the margin is not unlimited, we say really is not a fair reading and fails to give full effect to that case. Of course, and we know the Divisional Court later said, well, it's not on the same issue, it's about whether you have to have abortion for certain things.
One has to read the whole sentence,
I mean, my Lord, my submission that this is a dramatic understatement of the effect of the Human Rights Commission case applies to the whole sentence. It goes way beyond, we say, demonstrating that the margin in the field of abortion is not unlimited. It's a notable finding of the majority of the Supreme Court, some very distinguished members of the court in the field of abortion, where if the divisional court was right in its approach, this is all a very wide margin, the court shouldn't be interfering at all. Paragraph 125, the divisional court says, thirdly, it's important to bear in mind that Parliament gives a choice to women. It does not impose its will upon them. Now, I don't ignore the rest of the paragraph, but that is, in our submission, an astonishing sentence for the divisional court to include. I don't want to be unfair to them, but what they seem to be saying is that it is a point in favour of Section 11D that it doesn't require women to abort disabled fetuses. Parliament does not impose its will upon women. It gives them a choice. I don't want to be unfair, but it is very difficult to understand what they do.
I'm not taking.
I'm not taking
this point. No,
what you're saying.
I can understand that you might say that can't possibly be a complete answer, but surely what they're doing there is they're comparing what we have with something obviously unthinkable, which would be an obligation to have a termination. Now, I mean, you may say that that doesn't take you very far at all, but it's surely the concept of choice is a feature of the legislation, which the court was entitled to note. You may say it doesn't take matters very far in this context, but well, I don't know why it's, in a sense, attracted quite such a strong response.
Well, I think that there is.
I don't know whether my lady was.
Well, yes, I just could not understand the point you were making.
Well, these are
certainly not the strength of it.
So these are the divisional court's relatively short list of reasons in favour of compatibility of Section 11D. And one of these reasons is that Section 11D gives a choice to women as to whether to have an abortion of a disabled fetus. It does not impose its will upon them. And I think my Lord reads it in the same way as I did. But I would go further than saying it doesn't take one very far. It's a deeply insulting point to make in favour of the legislation to a group of disabled rights campaigners to say it's a positive feature that Section 11D doesn't require abortion in these circumstances.
Well, obviously, this has touched a nerve that, and I take it seriously for that reason. But I'd understood this was said in the context of the proportionality issue, and I think we all might easily come to the conclusion that if nobody else's rights were involved, then your case would be unstoppable. But the difficulty in this area, as everybody understands, is that it's a balancing of rights, and that what is, I think, being alluded to here is a feature of the balancing of rights and thinking about the other side of the coin. Now, anyhow, I'm not trying to tell you that you shouldn't be astonished by that, but I think that that's what is being alluded to there.
And Lord, I don't disagree that may be at the root of what they are saying, but
I think we've got, I mean, it's a list of how many, 3, and then we've got 4, 5. I mean, it's a sort of 5-point list that they're making here, aren't they?
Yes.
Of which this is just one of the points. Which
it is, but it's a point which we say not only doesn't take very far at all, but really perhaps ought not to have been made.
All right.
So then 126, this looks like the fourth reason, although scientific...
Late diagnosis.
Yeah. There are still conditions which will only be identified late in pregnancy after 24 weeks. We accept that, but that's not the position for Down syndrome. And the point as to overbreadth is that the section makes no attempt to distinguish between conditions which are detectable before 24 weeks and so could be dealt with under section 11A, and other conditions which for which section 11A would not be sufficient, and one needed to have a longer time limit. And we say it simply isn't an answer to overbreadth to say, well, there are some things that you need a longer time limit for. And the second sentence of 126, as the professor explains, there will be circumstances where a woman only becomes aware of the pregnancy very late on in that pregnancy. Of course, that is right, but that wouldn't be a sufficient answer under section 11A if the fetus was not disabled. A woman who only found out late in pregnancy would not be able to have an abortion. It's only the fact of disability which permits that under section 11D. And 127 is the point that I've already alluded to. That one may or may not be able to have an exhaustive list of fetal abnormalities rather than having somewhat broader terminology. We've dealt with that in paragraph 51 of our skeleton argument, and it wasn't our submission that there must be a list of conditions, an exhaustive list of conditions. That is not an answer to overbreadth, we say. Now, pausing at the end of this list of 5 points, one then has to ask oneself what the divisional court did not take into account in its balancing of the various factors. And there were important matters, we say, which were not weighed in the balance. Our skeleton, paragraph 45 to 46. What we point out is that the divisional court did not proceed on the correct basis that Article 8.1 was engaged and that there were interests and interferences which arose under Article 8.1, which then felt to be justified and which weighed somewhere in the balance on the issue of justification. So what the divisional court did not weigh in the balance was the significance of the impact on people like Heidi of the current state of the legislation. Nor did it make any reference to the interests, or as we would have it, the rights of the fetus, or indeed the interests of the community in protecting unborn life. So there's simply this short list of 5 points, but you cannot conduct a fair balancing of the issues under Article 8 unless under Article 8.2, unless you acknowledge what got you there in the first place, which was the stigmatisation and negative stereotyping that we complained of. So this is all on the assumed basis that we were right under 8.1. But none of that then feeds through to the 8.2 analysis. So, unsurprising that the balance came out in the way that it did when the divisional court, in its list of 5 reasons, didn't weigh and didn't assess the particular matters which got us there in the first place. And, well, that is a plain error of approach to the proportionality analysis in our submission. So it's our skeleton 45 and 46. And there are similar, we would make similar criticisms under Article 14, and that's 47 to 48 of our skeleton, referring to 143 to 144 of the divisional courts.
What's that adding in substance?
Well, what it adds to the proportionality analysis is the very weighty reasons for disability discrimination, or the very weighty reasons which the divisional court acknowledged have to be shown to justify disability discrimination.
But it's the suspect ground.
As a suspect ground, and we had specific authority on stereotyping of disabled people.
So in a sense, 14 in this context is emphatic, as it were. It's lending emphasis, you would say, to your submissions under Article 8.
Yes. I mean, ultimately, this is a case about difference of treatment between disabled and non-disabled fetuses. We put it first under Article 8, and we emphasise it under Article 14. So then, briefly under Article 2, I go back to paragraph 12 of our skeleton argument. And you need to have the divisional courts ruling on Article 2 at 62, para 62 of its judgment. And a point my lord put to me earlier, the European Court has never decided that a fetus, even one post-viability, is the bearer of convention rights, including Article 2. Now, we would say that the case law is far more nuanced than that sentence suggests, because the court has never ruled on the position of a viable fetus like Aidan, and nor has it ever said that Article 2 can never apply to unborn life. And even the paragraph which the divisional court quoted from Vaux and France, paragraph 80, which you see in para 49 of the divisional court's judgment. It's a discussion of the case law examined to date. Goes on, the convention institutions have not ruled out the possibility that in certain circumstances safeguards may be extended to the unborn child. So the position is a nuanced one, and our case, we say, simply cannot be dismissed on the basis that there isn't a case in Strasbourg which decides this. This would be new ground, but it's not, for reasons I'll come on to in a moment, inviting the court to develop new principles of convention law. It's applying the existing principles to a set of facts which Strasbourg has not yet considered.
I mean, it's quite curious because this is not a new issue. It's as old as the hills. This sort of controversy.
Well, my lord, it is. I'm sorry. It is as old as the hills. It is curious, but it is a feature of the case law that the relevant cases are few and far between, and they are. Vaux in France is really the most up to date one.
Yes.
That's itself not a new case in Strasbourg terms. Para 62 of the divisional court, the European Court, the final sentence, the European Court has not merely recognised that the fetus has interests, but has also referred to the fetus as having rights. And we set out the text in our from ABC in Ireland in paragraph 12(4) of our skeleton argument. So,
just a moment. Remind myself of that.
So 12(4), it's para 213 of ABC in Ireland.
Yes.
Well, this is another example of my complaint about the approach of the divisional court. Whatever way this case is ultimately decided, it's not an easy case. There are not easy answers. And here it was not an easy answer to say simply, well, Strasbourg has only recognised the fetus as having interests and not as rights. That's not a fair reflection of the case law. It's not an easy route through. And then, as the Strasbourg court said in Vaux in France, the question of when life begins and the protection of life begins is a matter within the margin of appreciation of states. But our point was then, well, domestic law does protect human life before birth. It does protect the life of the viable fetus, see the offence of child destruction, but it only does that for the able-bodied and not the disabled. So in terms of whether we're within the sphere of Article 2 right to life at all, and the answer to that point, given in paragraph 63 of the Divisional Court's judgment, is that the sentence for child destruction is different from the sentence for murder. Well, it is, but that's not the point. The point is domestic law protects the life of the viable fetus. The margin of appreciation, which you recognised in Vaux, has been exercised by the UK to protect life before birth where the fetus is viable. And our complaint, in essence, is that that protection only extends to the able-bodied and not to the disabled. So it's not an Uller case, a pure Uller case, where I have to say if Strasbourg were to be faced with this case, then it at least arguably would decide it in my favour. I mean, I do say that, but our primary submission is this is a particular context where Strasbourg has put the ball back in the court, as it were, of domestic law, and domestic law has protected life before birth, but done so on a discriminatory basis. and we give a number of other protections in domestic law in paragraph 13 of our skeleton, not just the offence of child destruction.
Yes.
So, well, finally, we say realistic prospect of success, but also other compelling reasons for the appeal to be. Oh, I'm sorry. Before I get to that, I gave you Jepson. I put Jepson up on
Yes.
the bench. Well, the only reason I refer to that it's
a historic note, isn't it? The last time that this has been directly raised, case where you say the supposed disability was relatively trifling.
Yes. And it's not going to win any appeal. I entirely accept. But if you look at the way that the divisional court dealt with it in paragraph 69, 69 and 70.
Just a moment. Where are we looking at Jepson in the paper copy?
So if you look at, so can we start with para 69 and 70 of the divisional court's judgment, and then I'll show you. So,
I'm just confused because we have.
Sorry. You've got a paper copy of Jepson on your bench.
Yes.
And
what?
Paragraph 8 of Jepson tells you what the relief was that was sought, and so what the arguments were in the case. And they're actually very similar to some of the points that we make.
Yes, got paragraph 8.
And then you look at paragraph 70 of the divisional court's judgment.
Yes.
Where Jepson is said not to be of material assistance, permission decision only. Yes. More fundamentally, that case did not concern the compatibility of section 11D with the convention rights.
Yes,
that's just wrong.
It was point D, paragraph 8, third last line.
Well, yes, it was C and D in paragraph 8. So again, it's just an error. It's not going to, as I say, win me the case, but it's very surprising that in seeking these easy answers to the appellant's claims that sort of mistake was being made. So, some other compelling reason. We say these are profound and important issues, not addressed in the case law, domestically or in Strasbourg, of great importance to many people. And finally, and Jepson is just another illustration of it, the divisional court simply did not do justice to the arguments before it in a case where it was absolutely vital that it do so, even if it was to find ultimately that the claim failed.
Do you want to say anything more about the point that I raised with you earlier, which was the scenario in which you made sufficient progress on engagement of Article 8, but not any on any of your other arguments? I mean, I appreciate that's hypothetical at the time being, but what do you say about that?
Well, if you're only persuaded that there's an arguable challenge to the Article 8.1 finding, then I accept there's no real prospect of success of the appeal.
Yes, I appreciate you've made a good number of points in relation to justification and to proportionality, which,
yes.
But we can't, in a sense, grant permission to appeal only to send the case down a blind alley, as it were. That's
well, I think that's my point on other compelling reasons. Is that there is a basis, even if you did think that we only had a point on Article 8.1 and on nothing else, there is a good reason, we say, for the Court of Appeal to look at this case and look at the arguments properly.
all right. So, in fact, your position is that success on engagement of Article 8 would in itself be a compelling reason, or would feed into a compelling reason narrative.
Yes, because of the approach adopted by the Divisional Court to the other arguments. But I wouldn't have a real prospect of success if you were only with me on under that limb. If you were only with me on Article 8.1 and not on anything else.
No. Thank you, Mr. Coppell. Yes. Now, Ms. Smith, we have your response document.
Yes, page
Thank you.
78.
Yes, and we've read that. Now, are there any particular points that you'd like to make in response, bearing in mind this is not an appeal but an application for permission?
My Lord, yes, I could take the court to some features of the evidence and make some short points, but I don't want to take up time unless the court would like to address a particular point. Essentially, we maintain our position that permission should not be granted on any of the grounds. And I could make brief submission on those that would assist the court in amplification, but essentially that's our position.
Right. Is there anything you'd like to say in relation to Mr. Coppell's last point, which was that if we were to any degree taken with his argument about paragraph 102, that would or could provide him with a compelling reason?
Well, we've made the submission in paragraph 11 of our response that there is no compelling reason to grant permission, given we say, contrary to what my learned friend says, although this is an area of acute sensitivity and controversy which generates strong feelings, it is not a case which raises difficult legal issues because the legal principles are very well settled by the case law. And fundamentally, that the message in the case law is that this is a matter for Parliament. And in those circumstances, we submit that there can't be a compelling reason to grant permission to appeal. So that's our response on that discrete point. In relation to the Article 8 point itself, I should say that it wasn't that the Divisional Court decided that Article 8 wasn't engaged, it was that there was no interference. And in that respect, we would simply refer the court to the comments that were made in Lieven at paragraphs 38 and 40 about looking at all the circumstances before deciding whether or not there's an interference. So the court has Lieven.
Sorry, I just wanted to pick up with what you said a moment ago, but in case I mischaracterised what the Divisional Court found. Yes, it found that Article 8 was engaged, but it found that it was not engaged on behalf of these claimants.
That there was no interference with their Article 8 rights. It didn't say that it wasn't engaged at all, and the Secretary of State didn't put the case in that way. What the Secretary of State submitted was that there was no interference with Article 8 rights.
Well, in what way is Article 8 engaged, as you put it, on behalf of these claimants?
Because simply, by virtue of the submission, that this affects how they see themselves, that it affects the matters that my learned friend has spoken to, and indeed that his client spoke to. But the question of interference is a separate question, and as the Supreme Court decides in the UK, that does involve looking at all the circumstances, and we would submit here that in those cases that my learned friend has relied on, they are cases where there has been abuse of a particular ethnic group or publication of racist remarks. And the point we would simply make is that what the divisional court was essentially saying is that this is a legislative provision which is specifically designed to balance rights and interests, and it concerns an intensely private decision between a woman and her clinicians, and that the guidance makes clear that that's a fact-sensitive medical assessment. So in those circumstances, it doesn't refer to, still less stigmatise, those with particular medical conditions. So although my learned friends take an issue with the way in which the divisional court expressed itself, that in my submission is what it was saying. And so we would submit that there isn't a realistic prospect of success on that issue, because that case law is very different. But of course, the second point I've made in response to your Lordship's invitation is that it doesn't get the claimants anywhere, because the law is so clear on the latter issues. And again, I can make brief submissions about that if it would assist. But in my submission, in all the circumstances of this case, and where it's plainly a matter for Parliament, there is certainly not a compelling reason to grant permission. In fact, there's a compelling reason not to.
Right. Well, could I just go back to the distinction between whether Article 8 is engaged and whether it's been breached in legal language, but in lay language, whether you have the right or whether you don't have the right and it's been breached, or you haven't got the right at all. Paragraph 85 of its decision, page 23, having cited Article 8, the court goes straight to the fact that the decision to become a parent or not falls within the scope of Article 8, yes. And then goes on to say that restricting the ability to have an abortion comes within scope and interferes with the right, with the woman's private life, which again, not a surprising statement, but where it may be in the following paragraphs, where is the court finding that Article 8 is engaged in relation to people other than the carrying mother?
I accept, my Lord, it doesn't say that in terms. It's paragraph 102 that its finding is that section 11D doesn't interfere.
Yes, I understand that, but there appears to be a gap in that case in the reasoning. I'm not saying this is a criticism, because it may be the way that the case was argued.
It is,
But I understood in paragraph 102 where it is said that the legislative provision is focused on the rights of pregnant women and their medical treatment. That argument would seem to hold good for saying, well, really, these are not Article 8 rights of others. I mean, it's not necessary, obviously, to produce an answer to this, but it seems to me to be a little unclear as to whether they were finding that these rights were owed but not breached, or not owed.
My Lord, I wonder if I could just ask the court to look at paragraph 100.
Well, the two read together, don't they? Because 100 then reads into 102, because 102 refines it down to, as my Lord has said, focused.
But the point I would make is, of course, at this point, and the other way round to the way that Mr. Coppell made his submissions, by this point the court has decided, and rightly and unarguably rightly in my submission, that fetuses are not the holders of rights under the ECHR. It can be that their interests can be weighed into the mix. My learned friend referred to the ABC case, that the passage there, that the important word there is not the rights, but the rights invoked, because those were the rights that Ireland was relying on in that case. So in paragraph 100 in my submission, all the court
It was
was
rights
saying
and freedoms is what they described it as.
yes, but that those were the rights invoked in that case, balanced against the women's.
I think it's,
rights.
thank you for paragraph 100, because I think it's that I had in mind, which is your submission, that it says nothing about the rights of others, which is a submission that they appear to take to, because they accept your submission 2 paragraphs later.
Yes, and the submission, if it assists to see what the Secretary of State...
No, I don't. No. I'm sure.
But it essentially was, as I've submitted, that these cases are very different. There's no interference, and one has to look at all the circumstances. Those circumstances include that it's an intensely private decision, and also that there is extensive legislative provisions, as the court states, aimed at preventing such discrimination, and therefore there is no interference with their Article 8 rights, and that the Secretary of State's argument, skeleton argument, went straight to interference.
Well, the Secretary of State's argument was that you don't have rights. If you had them, they wouldn't be breached.
Well,
And if they are breached, then there's a good reason for it. Or have I misstated the first step?
the first step relates to the rights of the fetus, which is a discrete
Yes,
issue.
I understand that, but we're here talking
And the
about
second-
Article 8.
Yes, but paragraph 100, in my submission, I accept that the court says there's nothing about the rights of others,
Yes,
including
it says
either
mothers
person.
have
Yes.
got rights, but
Yes.
other people don't in this context. That's how I read it.
Yes.
Is that what your submission was? I stopped you going back to look
Yes.
at it, but
Yes, the submission, it's somewhat compressed, because what the Secretary of State does, it's page 107, first of all, of the bundle, is the Secretary of State's skeleton argument, which sets out the position in summary, and then paragraph 9...
I'm sorry, where are you looking at page 107?
Perhaps could I just invite
It's
your Lordship and your
4.1,
ladies?
isn't it?
4.1, the unborn are not the holders.
Yes.
And then at paragraph 9, that deals specifically with the abortion case law.
I'm just looking, because I'm having to move through the document page by page. I'm just asking you, do you deal in this document with the proposition that persons in the position of the claimant have Article 8 rights, or not?
We simply address whether or not those rights are interfered with. So that in my submission, we didn't contest that those rights did not exist. We said that they had not been breached.
Right. So that takes me back to the question I asked you a little while ago, which is, in what manner do such rights exist in your analysis?
Not talking about the fetus, but talking about adults.
we're talking about people who have been born.
Because they have a right to respect for their private life.
Well, we're talking about not just,
And
of course, everybody's got a right to respect for their private life. We're talking about in the context of abortion.
Yes, and there are many cases in the Article 8 field which deal with whether or not Article 8 is engaged in different contexts. So, for example, identity, ethnic identity.
Yes, but I'm trying to pin you down to the question of the existence of Article 8 rights in the context of abortion. I mean, either this wasn't ventilated explicitly, or it was. I'm just trying to understand whether it was or not.
My recollection is that the Secretary of State's oral submissions, and it wasn't me making them, were focused on interference. So in terms of does the existence of this provision per se, is the existence of this provision on the statute book versus the actual carrying out of an abortion interfere with the claimant's rights? That was the question under this particular head. So it wasn't. It's not the conduct of an abortion per se. It's this specific legislative provision, albeit that it permits.
But I mean, it would seem that you have to decide whether the rights exist before you go on to decide whether or not they've been breached. But we're not really finding the answer, are we?
My Lord, no, and I'm sorry if I've led the court down an unhelpful path. Essentially, the Secretary of State proceeded on the basis that the rights exist in her written submissions. It's at page 117 of the bundle.
Right,
And
let me just get there.
Simply addressed interference.
117.
117.
Paragraph
30. My learned junior has checked his notes and he says there was no oral argument about engagement. It went straight to interference.
Right, so your argument below dived straight in at the interference stage.
It did.
Anything else?
My lord, no.
Well, can I just ask this? If it goes straight in at the interference stage, how then do we read causal connection in 102?
Well, again, the Secretary of State submissions are at paragraphs 30 to 35, and one point that the Secretary of State makes is that there's no evidence of any connection between this legislative provision, which is focused on the rights of pregnant women, and any discrimination that continues to be suffered by those with Down syndrome. So that was simply a point that the Secretary of State made, and the Secretary of State also pointed out, in terms of looking at the facts as a whole, that there were extensive legislative provisions aimed at preventing any such disability discrimination. The central point, though, that the Secretary of State made was that this situation was very far from the situation in the cases. And if one comes back to fundamental principle in paragraph 63 of Elan Kane, the question being that the court should not go further than it could be confident that the Strasbourg court would go, our submission, effectively, is that these cases are very far removed. But it's right to repeat my answer to your lordship's question, which is that this, even if there were an arguable error here, it's essentially not a material one, because the court goes on to consider justification, and it was clearly right for all the reasons it gave, and indeed its decision in that respect is unarguably correct, given Elan Kane, which followed.
Yes, thank you, Mr. Koppel. Any response?
Well, just one short point, which is, if one is looking for the source of paragraph 100 of the Divisional Court's ruling, it must be in paragraph 9 of the Secretary of State's skeleton argument on page, I got it at page 110 of the bundle, where the relevance of abortion to Article 8 or Article 8 to abortion is characterised in successive subparagraphs as only in terms of the rights of the pregnant woman. That must be the...
My lord, yes, it is, but that section is simply in the legal framework section, so it's addressing the case law on abortion. It's not addressing the specific case law on stereotyping, because that's addressed under the ground.
Mr. Koppel, I only need before you sit down, I only need the most rudimentary working knowledge of how this fits together at the moment, because you'll appreciate we're not deciding any ultimate points. It strikes me that, as we heard a moment ago, that fairly much battle was joined over the question of interference, with not much being said on either side about the engagement of Article 8 in this specific context. You know, it's people other than the mother. Is that a working assumption? I'm really concerned with it in order to be correct about what we've understood the argument to have covered, and I'm really giving you the opportunity to put me right on that.
Yes. Well, I suppose 2 points, my lord. Firstly, and without wanting to complicate matters still further, there is, of course, we did pursue a case under Article 14, as you know, Article 8 remember Article 14, where the test is within the ambit of.
Yes.
And the line between engagement and within of.
Because under Article 14, particularly with a suspect right, one would be very slow, as it were, to find non-engagement or non-existent status or something of that sort.
Yes.
As you say, you say that by one means or another, one arrives by a fairly short road at interference or not, rather than pausing too much in the issue of engagement, and that is what this all reflects.
Well, one arrives very quickly at the issue of justification. On the way, we touched on yes, interference, yes, within the ambit of, and I think the problem and perhaps the confusion. Well, one could easily be confused by the way that the Secretary of State put the submissions on interference to interpret them as extending to these rights just don't exist for these claimants at all. When you read it with the description of abortion in Article 8 in paragraph 9. But my Lord, the bottom line we say must be that on interference, 100 and 102 of the divisional court, that the divisional court's approach was mistaken in 100 and inadequate treatment of the evidence in 102. I'm sorry, I can't provide a very clear answer to my Lord's question either.
All right. Now, what I'm going to suggest we do before we go on is to read, because I haven't done so, the statement from NCAP, which is supported by an exhibit. Just give me a moment. What we'd like to do, if we may, is to read that to ourselves. If there's anything substantive, rather than on the question of admissibility, that either of you want to tell us after that, then we'll hear you on that. But give us a moment. Anything further to say about that?
Lord, it supports the criticisms that we had made of paragraph 102 in particular, and what we say about the public interest and some other compelling reason. It's not it doesn't go much further than that, but it's from an expert organisation which was disturbed by the finding of by the way in which the divisional court put its judgment.
Thank you. Ms. Smith?
Well, very quickly, my learned friend hasn't addressed the Lieven Marshall criteria, but 2 points. The first, whether evidence could have been obtained with reasonable diligence for use at trial. Second, evidence would probably have had an important influence on the result of the case.
Well, I think the way in which this arises is in response to the judgment, so
yes,
I suppose it might have been said that the divisional court might have been expected to accept unchallenged evidence. So I understand your point.
Well, I just simply mentioned those principles for completeness, and also just to draw the court's attention that there was a witness statement from a Professor Sile which dealt with very similar points.
Yes, I say that. All right. Well, thank you for those arguments. We would like to be able to give our decision today, and therefore, what I'm going to say is that we will attempt to do so in court at 3 o'clock. Thank you very much.